Everybody, welcome to Division 1 of the Court of Appeals. We have two cases scheduled for 9 o'clock. The first one is People v. Terry. I see Counselor seated at the table and ready to go. After the oral argument in that case, we'll take a brief recess to reconstitute our division to hear the oral argument in People v. Fuerte Rios. Are Counselor here for that case?
For the people here.
Okay, thank you. I will briefly review our procedures. I should say at the outset that our division is pleased to be joined for the oral argument in this case by Judge Stephen Bernard, who's sitting to my right. As you know, we have 15 minutes for each side for oral argument. We have our traditional timer that starts green and turns amber when you have 5 minutes left and red when your time is up. There's a digital timer too that you can use to gauge your time and determine, if you're the appellant, how much time you wish to leave for rebuttal. We have all read the briefs and we've had an opportunity to review the record, so you may wish to focus your argument on the legal issues rather than the facts, but of course how you present your argument is up to you. As you know, there's a switch on the podium that you can use to raise or lower it to suit your convenience, and as you also know, we're live streaming the oral argument, so if there's any confidential information, you may wish to be careful as to how you refer to it. And finally, I would ask that if anybody has a cell phone with you, to make sure that it's off so it doesn't inadvertently interrupt us during oral argument. And with all that having been said, we're ready to go.
Good morning, may it please the court. My name is Matthew Fredrickson, registration number 47453, and I represent appellant Mr. Andrew Terry. The lower court deviated from the standard of the mandatory procedures authorized or provided by Rule 35C35. Having sufficiently alleged ineffective assistance of counsel, Mr. Terry was entitled to a full response from the prosecutor, an opportunity to reply, and a hearing. Denying Mr. Terry those procedures made the lower court err. This court should vacate its summary denial and remand for these proceedings.
Pardon me, hate to hit you right out of the box.
That's fine,
Mr.
Your Honor.
Fredrickson, but if I may, please. I understand that it's your position that your client was entitled to a hearing, so I'm asking you a hypothetical now, and I know you're not abandoning your position. But the hypothetical is this. Let's assume that the trial court did ask for a response from the prosecution and did everything up to the point that it could have asked for a hearing, but then it decided that based on the entire record that it could resolve this case. I know you say that it couldn't have done that, but wouldn't that in certain cases be okay if the record answered all the questions that were raised?
Yes, Your Honor, it would be okay, because given what the rule provides, that if the motion, the files, and the record clearly state that the defendant is not entitled to relief, the court can then at that junction rule after the terminus of all the required litigation, all the required responsive pleadings. In this case, no. Going to that second issue I mentioned in my brief, that Mr. Terry was specifically entitled to a hearing because what he was alleging required the addition of testimony, both of the experts that the appointed attorney indicated, as well as Mr. Terry and his trial attorney.
Let me ask one follow-up, and then I'll leave you alone, I
No,
promise. If that is so, if the court could have hypothetically resolved this if the record were adequate to do so, what prejudice would a defendant in that circumstance suffer if the court, for reasons that we don't know, errs by just not asking for a response from the prosecution? And that's the only thing that is missing. There's a full explanation of the defendant's position in writing, but just what's missing is what the prosecutor has to say. Where's the prejudice to the defendant?
Your Honor, I'm glad you asked that, because the proceedings provided by Rule 35C inure to the benefit of the defendant, because what happens is with the initial pleading, the initial petition filed by the appointed attorney as well as the defendant in most pro se cases is then countered with the prosecutor's response, where they're going to draw out probably a lot of what the court is already going to see as potential issues. But then with that reply, that additional litigation provided to the defendant by the rule, that reply allows them to deepen the response and respond to a lot of those initial issues still in that litigation stage before it even gets to the court, so we can respond to those items before the court even reaches the court. So it's additional complexity or depth added to the litigation provided by those two additional steps.
But Mr. Frederickson, why is a reply necessary, again, following up on what Judge Bernard was asking, if the court is able to determine from the motion itself that there's no basis to schedule an evidentiary hearing?
Your Honor, that would be the product of the prosecutor's response, but then what the reply would be able to do is to counter that before the court even had an opportunity to do that. I do think that in cases where there is an argument, as it is here, where a lot of it goes to strategy, that would have been pointed out by the prosecutor, but then we wouldn't even reach the court stage before the attorney, the appointed attorney, would perhaps draw attention to Ardolino, which talks about that in cases of strategy, that is something that requires a hearing so that testimony can be heard. It's that kind of back and forth that allows a much more complete image and picture to go to the court so that the attorney and the defendant have an opportunity to respond to those things.
So, Mr. Frederickson, with regard to the substance of your argument about the interpretation of the rule, what is your view about the sentence in Rule 35C35 that says the prosecution shall not respond to the motion until instructed to do so by the court?
Well, I would draw this court's attention to a division of this court's ruling in People v. Higgins, specifically 2017CA0517, where it draws attention to the fact that then once the appointed attorney or the attorney supplements the pro se defendant's petition, then the court must order the prosecutor to respond and the defendant to reply. So that must or that shall language is assumed or presumed by the language of the rule. So yes, the prosecutor is not meant to respond until ordered to do so, but the filing of that supplemental petition triggers the court to do that ordering, which would then have the prosecutor respond. So yes, that language is present in the rule, but by operation of the appointed attorney supplementing the petition as required by 35C35, that then triggers the court to order that response, and that's a requirement as People v. Higgins reads the rule and as the rule itself states. And then with that, both that response and that reply, the court would reach a junction, as Judge Bernard pointed out, where it could rule based on the motions, the files, and the record, but it couldn't go beyond there. It had to, if it wants to go beyond there, it has to have a hearing, and we see that in other cases. For example, People v. Smith, a recent case, 413 P. 3rd 195, a division of this court ruled that an attachment provided by the prosecution in that litigation could not be considered without a hearing, because essentially the court then is ruling on something outside what the rule anticipates. Motion, the file, and the record. If it's going to consider something else, it needs to have that hearing and allow for that fuller dialogue. Yes,
That's not what happened here, though. The court ruled based on the allegations in the supplemental motion itself. Isn't that correct?
That is correct, Your Honor, but I would point the court to specifically how the lower court dealt with the second issue and how it dealt with Dr. Fukutaki and her testimony and what that would be. The court drew upon its own opinion or its own knowledge of the facts to say, well, the only Fukutaki that we're familiar with would not have the requisite qualifications. So it was essentially doing its own additional or independent research into additional areas that were not presented in the facts already in the record.
Was that particular issue, though, preserved for our review? I know the arguments made, but I'm not sure that it was called to the trial court's attention so that it could correct that error if it's alleged as an error.
That it was essentially going on beyond its own record?
Correct.
Because specifically that argument came up in the motion for reconsideration of the court's ruling, saying that Dr. Fukutaki could provide this testimony. And then in the court's order denying that motion for reconsideration, it said that the only Fukutaki we're familiar with is this this mental health expert, not anyone who could provide a toxicology or kind of a more scientific approach, a more blood alcohol approach. And so at that point, Mr. Terry and his appointed attorney moved into the appellate proceedings, having already requested reconsideration. So I would suggest that even though there wasn't a specific objection to the court's treatment of that issue, how the court treated that issue is very much aligned with how People v. Smith resolved itself, which is where the court is doing that. The court is essentially doing that, and the court found that that was error to have considered something outside the record. Because the rule so requires the court to only look at the motions, the files in the record, when the court is doing what it did in Smith, like it's doing here, that is error that this court can reverse upon. If that answers your question, because yes, there was no specific objection to how the court dealt with that issue, but we're looking at how the court dealt with all of these different claims, and so many of them are resolved by the court with citation to strategy or citation to a resolution of facts that it itself hasn't heard a record on, and that's the problem. That's the reason why there's a hearing, is for that testimony to be received. I point this court to Ardolino, a case provided by our Supreme Court in 2003, which talks about when there are questions of strategy, rarely is the the defense attorney's thought process on the record, and that's the very reason why the court needs to hear about how that strategy was arrived upon to decide whether or not it was reasonable, decide whether or not there was the proper amount of investigation and legal research to arrive at that strategy.
So, Mr. Fredrickson, when I read that part of your brief, it sounded to me as if you were saying that whenever a defendant in a 35C motion was challenging trial counsel's strategy, that an evidentiary hearing would be required. Is that your view?
Yes, Your Honor. I do believe that is my personal view, and I believe that that's what Ardolino requires, unless, of course, the record specifically has the defense attorney's strategy on the record, which would be atypical for a defense attorney to go out of his way to say, this is why I'm making this choice, Your Honor, or doing this thing, and this is the research that I've done. I think that would be a violation of the client's confidences, and not necessarily a good idea when it's an adversarial process and you have a prosecutor on the other side who wants to know the ins and outs of those things, and you're going in saying, here's why I'm doing what I'm doing. So those things are never going to really be on the record reasonably, and that's why I think Ardolino says you need to have a hearing so that at that point confidence can be waived and the attorney can come in and say, here's how I decided not to pursue this expert. Here's how I decided to, like in this case, endorse an insanity defense, not do any research into that insanity defense, go to trial, and halfway through abandon that insanity defense. I mean, those are kinds of things that are very peculiar and need further investigation in a hearing, so the court can not only hear from the expert that Mr. Terry's appointed counsel was working with, Mr. Terry himself, but also Doug Romero, the attorney appointed, or the attorney working with Mr. Terry, to figure out why he made that choice. After 2 state offices said there is no insanity here, but then he decided not to continue to pursue the mental health issues that he had told Mr. Terry were such a strong defense in this case. And it's for that reason that Mr. Terry is making these factual assertions, and the court is resolving them based on its own opinion. That is what's concerning and requires that hearing, so the court has everything in front of it and is acting as a neutral arbiter and not someone who is deciding the facts based on its own conclusions. That's not the role the court is to play. It's to receive all of this information and then resolve the issue as a neutral arbiter. With that, I would turn to the 5 claims that Mr. Terry raised. There are 5, and each one of them would require a hearing. The first 2, the provenance of the defenses that were not pursued and why they weren't pursued, the mental health defenses as well as the voluntary intoxication. Then we have the lesser non-included offenses for which Mr. Terry and his appointed counsel made a record, or stated or claimed that those would have been valuable in this case, specifically because the jury was thinking about issues of mental culpability and lesser offenses. And why the Trujillo case says we include lesser non-included offenses is so that a judge or a jury that's grappling with those issues can have a second, or an option, an alternative, a way out. And this jury was, I think, looking for that, having acquitted Mr. Terry already of the deliberation and intent form of attempt murder. So I think that there would have been value to those lesser non-included, and for that very issue, you know, an expert defense attorney could come in and say, in my experience, in cases like this is what's going on, this is what's happening, and a jury is going to be receptive to something like that, to give the court that reasonable probability that having included those lesser offenses, those lesser non-includeds, would have made a difference in the outcome, which is what Strickland requires under that second prejudice prong. As for the other two, we have the motion to suppress the arrest that was neglected by the trial attorney, which under Kimmelman v. Morrison, we have our standard for how to look at that and whether or not that issue had merit, and whether or not, if that motion was successful, whether or not that suppressed evidence would have had an impact. That can be fully litigated with the officer's testimony and expert testimony as well as the proportionality review to look at whether or not that would have survived an abbreviated review into a much more searching review. So with that, I would ask this court to remand for the full process as required by 35C35 for the prosecutor to respond to everything, for Mr. Terry to be able to reply, and then for a hearing on all of these claims. And with that, I will reserve the remainder of my time.
Very well. Thank you, Mr. Fredrickson.
May it please the court, my name is Jillian Price, registration number 40815, and I represent the people. The defendant's reading of Rule 35 creates an all-or-nothing situation that would divest trial courts of their ability to serve as a gatekeeper in the context of post-conviction motions. Now, to draw this court to a hypothetical, reading Rule 35 as a whole, sections C3, 6, and 7 both contemplate a claim-by-claim denial in a post-conviction motion, specifically for successive claims. Clearly, there were no successive claims here, but the point is that Rule 35 allows a trial court to summarily deny claims that were or could have been presented in a prior proceeding. So let's say that a post-conviction motion presented some successive claims and some arguably meritorious claims. By virtue of the arguably meritorious claims, the trial court would not be allowed to summarily deny the motion in total. And under Mr. Terry's reading of Rule 35, that motion would then need to be fully presented, or rather fully litigated by both the prosecution and defense counsel, including those successive claims.
Except that, as I understand Mr. Fredrickson's argument, it would have to be fully litigated in the sense that the people would have to file a response to a supplemental 35C motion, but it wouldn't necessarily require an evidentiary hearing. Is that correct?
Yes, yes. After, under Mr. Terry's reading, following the full litigation by prosecution and defense, the trial court could still, under the rule, deny a hearing and dispose of the motion. The point that I'm trying to make is that it would be the epitome of judicial inefficiency to require full litigation on claims that could otherwise be disposed of by the court based on the motion, the file, and the record. And that is precisely what the court did here. The hypothetical is simply to illustrate the point that there is no principled reason to require the prosecution to respond to claims that lack merit. And that is what the trial court did here.
But how does your reading of Rule 35C, Ms. Price, square with subsection 5? And I know you're relying on subsection 6 and 7 about successive claims, but subsection 5 sets forth certain procedures when the trial court believes that there may be potential merit in a defendant's 35C motion.
I think subsection 5 is mostly directed when a defendant files a pro se motion. Subsection 5 directs the trial court to then forward that motion to the district attorney and defense counsel. And as we know from Davis and Higgins, the harm in not following that procedure, as was the case in Davis and Higgins, the district court's failure to forward those motions to counsel deprived the defendant of the opportunity to have defense counsel respond and add claims as necessary.
But under that subsection of the rule, the trial court, as I understand it, can rule based on the motion itself that it's going to deny the motion without any kind of a hearing or without doing anything further. But if it thinks that there's potential merit and then forwards it to the people, then that's when the procedures in subsection 5 are triggered. Is that consistent with your understanding?
Yes, so subsection 4 allows the trial court to dispose of motions where the motion files and records allow the court to do so without any further inquiry. And so my argument is that when you have a claim that the trial court can dispose of based on the motion, the file, and the records, that claim can be disposed of. If there is an arguably meritorious claim that cannot be denied in that fashion, then that should be forwarded to the district attorney and defense counsel. And the trial court here did comply with those requirements. The defendant filed his pro se 35C motion. The trial court determined in its March 23rd order at page 447 of the court file that all but that 3 of the grounds for relief were not meritorious, and the 4th one concerning the conveyance or not of a plea offer was decided that should be forwarded to the district attorney and defense counsel. That's what happened. The public defender had a conflict. Alternate defense counsel was appointed. Alternate defense counsel filed its supplemental petition. And the trial court then, in the same way that it did in response to the pro se motion, disposed of the claims that the record allowed it to do and directed the district attorney to respond to the arguably meritorious claim, which in this case was later withdrawn voluntarily by the defendant. So the trial court has complied with the requirements of Rule 35.
So is it your view that a trial court in this situation has the discretion to do what the trial court did here and order a response to some but not all of the claims in a supplemental 35C motion?
Yes, and that circles back to the hypothetical that I articulated earlier, where we have non-meritorious claims, and the example I used was successive claims, but where we have clearly non-meritorious claims and some, or at least one, arguably meritorious claim. Those claims warrant responses under Rule 35. The claims that the trial court was able to dispose of based on the record, as the trial court did here, did not. And it would be inefficient for a court to rule that all claims, especially the non-meritorious ones, require full litigation. Indeed, even if this court were to determine that the trial court's order were void, and even if this court did remand for the prosecution to respond, there would be nothing stopping the trial court from again looking at the record as it did and deciding on the record that none of the claims were meritorious.
What is your response to Mr. Fredrickson's contention that if the procedure had been followed the way he believes it should have been, then the people would have responded to all of the contentions and he would have had an opportunity to reply and thereby, as he described it, deepen his responses to his original allegations?
Well, any deepening of those responses would not change the facts that we have in the record, which the trial court detailed well in its written order. The record in this case, and as articulated in the people's answer brief, shows that none of the claims that were raised have any merit. There is no showing of either deficient performance or prejudice. And again, on the record in this case, there is nothing to prevent the trial court from simply reaffirming its order.
And how do you respond to your opponent's contention that the record on its own simply does not contain the information that was necessary in order to determine why counsel made certain decisions that he made that, I guess he's supposing that everything that the trial court did was based on speculation as opposed to something that's actually in the record. How do you respond to that?
Well, let's take the voluntary intoxication claim, which was discussed at some length here today. The voluntary intoxication defense would only have applied to specific intent crimes, number one. Number two, the jury was presented with a voluntary intoxication instruction, and that appears, that appears at page 218 of the court file. So that defense was before the jury. Based on that, there is no way to establish prejudice. The jury was presented with that defense, notified that it would have applied to the specific intent or to the specific crimes with respect to Officer Richter, and that was something that the jury could consider. So even if it was somehow deficient for counsel not to make a verbose argument about that at trial, it was still in front of the jury, and there is simply no way to establish prejudice in that respect. So counsel's argument that every claim of deficient strategy would require a hearing would again put us back into the realm of judicial inefficiency. In a claim like this, where the instruction was presented to the jury and the defense was before the jury, there's simply not any way to establish that prejudice prong under Strickland, and the trial court's disposition of that claim was proper.
Pardon me for interrupting, Ms. Price. Sure. We're kind of busy today. Pardon me for interrupting, but I want to go back to something Judge Talman asked you. When you were responding about the deepening question, do I understand you to say that because you didn't feel, based on the record in this case, that that would make any difference, that at least in this case, if there was any error in not sending the case to the prosecution and asking for a response from the prosecution, that error would have been harmless because there had been no prejudice to the defendant here?
Well, that's certainly another component of the argument. Again, as articulated in the brief, none of the claims that the trial court disposed of, or rather the defendant has not made his requisite showing of prejudice in any of these claims. And these, again, as with the voluntary intoxication instruction, these are things that are evident from the record itself. And frankly, there's no deepening of an argument where we have an instruction that is already presented to the jury that would have altered that conclusion. So in this case, certainly, where the record contains that information, there is no prejudice and therefore no harm to the defendant in the trial court's ruling. Does that?
Yes, thank you.
Thank you. Unless this court has any further questions on the reading of Rule 35 or indeed on any of the issues in the briefs, the people respectfully request that you affirm the district court's order. Thank you.
And thank you, Ms. Price.
Your Honors, first I wanted to return to that kind of prejudice idea that we were talking about, because when I sat down, I was trying to look for the specific quote from either People v. Higgins or People v. Davis, which dealt with the prejudice and kind of what the procedures are supposed to mean for the defendant and why that response is so necessary for the defendant. I can't remember, I apologize, if it's Higgins or Davis, but they both dealt with kind of a response from the public defender, but in different ways. In Higgins, it was the fact that the public defender didn't get the chance to respond. That was the problem. In Davis, it was the fact that the public defender wasn't notified of the petition in the first place, and then there was an affidavit attached to the people's response from a parole board member. So I want to say it's Higgins that talks about why that response is so necessary, because that's what the issue was in the case, was that the public defender didn't get a chance to respond, and why that division reversed and remanded for that response was it has a good discussion about why that reply is necessary and why it inures to the benefit of the defendant, because it allows for so much more in that litigation for the court to rule upon. The second piece that I wanted to talk about was what we're talking about with this voluntary intoxication defense, which I think is a good kind of, just a good illustration in this case, because what Dr. Fukutaki could have come in and testified to would have been the difference between what Doug Romero, the trial attorney, provided and what should have been done, so the court can weigh the deficient performance and the prejudice of that marginal impact of that testimony. Yes, the idea was presented to the jury, but it could have been presented with an actual witness, Dr. Fukutaki, who could have said at this time, Mr. Terry, and I apologize, if I could have just a moment to say, Dr. Fukutaki could have said, this is why he was so drunk and this is how drunk he was on this occasion. And that's that marginal benefit. And that could have been presented at a hearing. So I would ask this court to reverse and remand for that hearing. Thank you.
Thank you, Mr. Fredrickson. Thank you, Ms. Price. Again, we appreciate both of your helpful arguments this morning. The case will stand submitted and a written opinion will issue in due course. As I mentioned at the outset, our division is going to take a brief recess now to reconstitute the division, and so the court will be in a brief recess, and the bailiff may so announce. Welcome again to Division 1. I see counsel are set up for the argument of People v. Fuerte Rios. I know counsel for the people were here when I did my original advisement. I assume you're Megan Morris, is that correct? And may I assume you're already familiar with our procedures? Yes. Okay, so I will dispense with my usual summary, and so we can just go ahead and get started with the oral argument.
Good morning. My name is Megan Morris, bar number 43963, and I represent Mr. Fuerte Rios. This case implicates the fundamental nature of sentencing. Is it permissible, as the state argues, for a court to impose a sentence regardless or heedless of where it falls on a statutorily defined range, with no intent as to whether that sentence should be a low, mid, or high range sentence? I don't think that it is. Instead, the statutory range must serve as the starting point for and the basis of any court's sentencing decision. This approach is necessary to protect the goals of sentencing. Those include to punish a convicted offender by assuring the imposition of a sentence he deserves in relation to the seriousness of his offense. I'm not sure how we would assess that if not in relation to that legislatively defined sentencing range. Similarly, the legislature has said that a goal of sentencing is to assure the fair and consistent treatment of all convicted offenders by eliminating unjustified disparity in sentences, providing fair warning of the nature of the sentence to be imposed, and establishing fair procedures for the imposition of sentences.
So, Ms. Morris, is it your view that a trial court can never reimpose the same sentence if it is instructed by an appellate court to use a different sentencing range?
I wouldn't say never, but I would say that it ought to be rare, and that if a court is going to do that, it must have a very persuasive justification for doing so, and it needs to articulate that on the record. But I think that there should be at least sort of a presumption that where the legislatively defined sentencing range is something drastically different from the one originally contemplated by the court, that decision, its sentencing outcome is going to change.
And is there any authority for your proposition that that's where the presumption begins?
So I would point this court to Molina Martinez, which talks about, and in that case, the Supreme Court cases are talking about sentencing guidelines. So I think that those principles apply with even more force here, where what we have is not just guidelines, but in fact the law, the sentencing law. But Molina Martinez talks about the idea that the sentencing range or the guidelines must anchor the court's discretion, and it talks about the fact that in most cases what that means is that there's going to be a different outcome when the sentencing range contemplated by the court is different. I would also point this court to Yates, where the court found that in that case there was the court originally contemplated sentencing for 11 counts of just a second. The sentencing range, the court was originally sentencing for 11 criminal contempt counts. It imposed 11 one-year concurrent sentences. The Supreme Court held that, in fact, only one count of contempt was established. And so at that point, the trial court on remand reimposed that same one-year sentence. The Supreme Court held that that was inappropriate and that the district court appeared not to have exercised its discretion in light of that diminished sentencing range, but just to have sought merely to justify the original sentence. And so I think that principle applies here, that there's going to be this idea that where the sentencing range drastically decreases, that should and must affect the court's decision in the ordinary case. And that is what should have happened here as well.
What would the court have had to say in order to satisfy the requirements to impose the same sentence that it imposed?
Your Honor, I'm not sure. I mean, I think it would have to be some sort of special circumstances, and certainly something different than what the court said here, which is that just simply for the same reasons it articulated at the original sentencing, it was imposing the same sentence. I don't think that based on those same reasons, again, if we're starting with the idea that the court must anchor its discretion in that legislatively defined sentencing range, it cannot simply for the same reasons it articulated the original sentence, reimpose that same sentence where the sentencing range has drastically decreased. What we have here is, at the original sentence, the court thought that the sentencing range for each sex offense was 10 to 32 to life. It imposed 12 years, so 2 years above the minimum for each of those sex offenses. And for each burglary offense, it thought that the range, and the range was 4 to 12 years. It imposed 6 years for each burglary. So notably, what the court is doing at that original sentencing is imposing 2 years above what it believes to be the mandatory minimum on every single offense. So I think that's at least circumstantial evidence that what the court would have done here at the original sentencing, had it been aware of the correct range, was to impose 6 years to life on each sex offense. And instead, then, rather than adjusting that sentence in light of the new range at the resentencing, it simply justified its original sentence that it had imposed based on this belief that the range for the sex offenses in total was 40 to 128 years to life, rather than being 4 to 48 years to life.
So, Ms. Morris, I hope you can clear up my confusion. The Court of Appeals, in its prior decision, said that the trial court erred in imposing consecutive rather than concurrent sentences.
That's correct.
And so there was no discussion about whether the specific range for each sentence.
Yes.
And yet your argument is not at all addressed, as I understand it, to the difference between consecutive and concurrent sentences. So it seems to me that there's a disconnect, and that's why I'm confused. So
Sure.
can you clear up my confusion?
So there's two things there. One is that my argument is in part based on the concurrent versus consecutive nature of the sentences in terms of the total range that the court could have imposed, that leads to, because it can be concurrent, it's 4 to 48 years to life, rather than the mandatory consecutive, it would have been 40 to 128 years to life with that changed range plus the mandatory consecutive nature of the sentences, which the court believed to be the case. But you're correct that the original opinion in this case does not specifically address the changed sentencing range. And that's in part due to my fault, which was that I handled the original appeal, and neither Mr. Lofgren or I in the original appeal realized that these were not crimes of violence. And so that issue didn't come up until our petitions for rehearing. We both filed petitions for rehearing pointing out that these were not crimes of violence. And then at that point, the court modified its opinion to explain that these were, in addition to not being mandatorily consecutive offenses, they were not crimes of violence as well. So it doesn't address the changed range, but it does note in its opinion that they are not crimes of violence, which I think certainly should have been a cue to the trial court that would change the sentencing range. And indeed, on remand for resentencing, trial counsel did present that argument to the court and explain that drastically lowered the sentencing range for each offense.
So does that change, or this new understanding that the offenses here were not crimes of violence possibly explain the trial court reimposing the same sentence?
Well, to the extent, if it didn't understand, if it in fact did not accept trial counsel's explanation of the changed sentencing range, that would explain it potentially. It never articulated what it believed to be the correct sentencing range on this remand for resentencing. So I think that's certainly one possibility. The other possibility is that even if it did understand the correct sentencing range, that at that point it simply still chose to impose the same sentence. And I think either way that would be error.
So there's no circumstance in which the court could have imposed the same sentence? It had to impose a different sentence in your view?
Well, I think that is the presumption, and just on the record here, I don't see any facts that would have justified it imposing the same sentence based on both the change in the concurrent versus consecutive nature of the sentence and the drastically reduced sentencing range. That again, I think there would have had to be really compelling facts and something that the court spoke about in terms of extraordinary circumstances to justify that. So no, I don't think that based on the record we have that the court could have properly imposed the same sentence without making some additional findings. To briefly turn to the second issue in the briefs, unless the court has further questions on that, I think the court also failed to give sufficient consideration to Mr. Fuerte-Rios' rehabilitative potential here. The court sentenced a very young man who was 24 years old when he committed these offenses to grow old and potentially die in prison. As of now, he will become parole eligible when he is 76 years old. His youth and lack of criminal history weighed strongly in favor of giving him the chance to rehabilitate, to engage in sex offender treatment, and to earn his freedom if he was able and willing to do that. And the court failed to give him that opportunity here. Under the Supreme Court's decisions in Cohen and Edwards, I think that was incorrect, and that the court failed to properly consider the weight of rehabilitation in Mr. Fuerte Rios' youth in making its ultimate sentencing decision. And so I think that's another alternate ground for reversing and remanding for the court to impose a lower sentence here. Unless this court has further questions, I would reserve the remainder of my time.
Very well, thank you, Ms. Morris.
May it please the court, my name is Jacob Lofgren, registration 40904, on behalf of the people of the state of Colorado. I want to start by making one thing clear about the Court of Appeals opinion, the original one. It did say consecutive sentences were okay. What that opinion said is that they were not mandatory by law. So the court, when it was remanded, had discretion to impose concurrent or consecutive sentences. And in fact, the division that handled that prior appeal specifically said, on remand, the district court is permitted to reimpose consecutive sentences if it feels they're appropriate. So I wanted to clarify that to start. I also wanted to say, we also agree that the range is important. I mean, I don't disagree with the defendant on that, but the sentence in this case fell squarely within the applicable range. So there's no reason here that the court violated its authority or abused its discretion. The sentence was within the appropriate range.
Well, Mr. Lofgren, Ms. Morris said that Judge Gilman never said that what she believed the proper range to be. Is that correct?
I do agree with that. At the resentencing hearing, she never specifically says, I agree with you that that's the range, or she never specifically explains what the range is.
So then how do we know that she applied the correct sentencing range in resentencing?
Well, I would make two arguments on that. The first is defense counsel made a very clear argument as to here is what the applicable range is, and the court didn't indicate any disagreement. The prosecutor didn't object or indicate any disagreement. I think by the nature of hearing that argument and not saying, wait, is that's different than my understanding, the court was kind of implicitly indicating it agreed. More so, the sentence the court chose to adopt fell within that range. So even if the court did not specifically say that I understand that to be the range, the sentence here was within that range, so we can implicitly, again, understand that the court understood the range and sentenced within that range.
And how do you respond to your opponent's contention that we start off with a presumption that the court is not to impose the same sentence absent a detailed explanation for?
Yeah, I fully disagree with that because first of all, I don't think there's any authority that suggests that the court is required to give a different sentence on remand, especially in a case like this where the Court of Appeals essentially said, hey, we just want you to decide whether you wanted consecutive sentences discretionarily as opposed to mandatorily. And when it was sent back, the court basically said, yeah, even in my discretion, I think consecutive sentences are appropriate here. So I think consistent with this court's opinion and consistent with the lack of authority mandating otherwise, that discretion remains with the court. And even if there were some obligation to put special circumstances on the record, they exist in this case. As the district court recognized both at the original sentencing hearing and at resentencing, the facts of this case are fairly egregious. This is not a one-off sex assault at a drunk college party. This is 4 times where this defendant came back and raped the victim on 4 separate occasions. On 2 of those occasions, he broke into the house to do so. So this is a repeat pattern offender who did discrete acts of sexual assault on 4 different dates. This is not a simple case or a not egregious case. The facts here are fairly aggravated as the court recognized. I'll make sure I'm not missing anything on that point. Yeah, as the court recognized, in fact, the court described it as terrorizing the victim. In addition to the 4 separate incidents, the defendant also harassed the victim, threatened the victim's family members if any of them revealed his crimes. This was a fairly egregious case, and that justifies the court sentence. With respect to the consideration of rehabilitative potential, This court has repeatedly recognized that there is no need for a point-by-point discussion of every possible sentencing argument. And in this case, the defense counsel made very clear below all of the arguments you heard here today. The defendant's young, he's amenable to treatment, he had a limited criminal history, so the court was aware of all of those things through defense counsel's argument and through the PSIR. And balancing that with the aggravated factors I just described, the court still said, no, the aggravated factors here justify a lengthy sentence, particularly in light of the numerous offenses that occurred in this case. And I wanted to briefly address the two key cases that defense counsel relies on in support of the contrary. One is Cohen, and in that case, the court's opinion, the Supreme Court's opinion, the Colorado Supreme Court's opinion, discusses at length the fact that it is just one burglary with a defendant with no criminal history. There was no harm, no physical harm to any of the victims, and he was not a repeat offender. None of those circumstances are similar to the case we have here. We have repeated incidents of criminal activity, and we have specific injury to the victim, sexual assaults on 4 separate occasions. So Cohen doesn't suggest, as defense counsel argues, that rehabilitative potential should somehow overcome the circumstances of the case. Quite to the contrary, they say, in that case, the circumstances of the case say, look more at rehabilitative potential because this was not a very serious offense. Same with Edwards. Edwards involved a series of drug sales over a span of a couple of weeks. And in that case, at the sentencing hearing, the district court specifically said, I am rejecting your argument of rehabilitation and finding you can't be rehabilitated. It was that clear comment pointed out in the Supreme Court's opinion that was the reason they remanded for resentencing. They said, no, the court didn't just overlook rehabilitation here, it specifically rejected it and refused to consider it. That's not what we have here. At no point did the district court indicate it was refusing to consider rehabilitation. Instead, we have a court that said, no, the aggravating factors are more severe here. And if this court has no further questions, I would ask this court to affirm. Thank you.
Thank you, Mr. Lofgren.
In response to the argument about the facts of this case being aggravated, I would just note that what the court did at the original sentencing was to impose a sentence, again, on each sexual assault that was only 2 years above the mandatory, what it believed to be the mandatory minimum. So to the extent that it believed the facts of this case were aggravated, again, in relation to the sentencing range it believed to be the case, it still imposed a relatively low sentence. And so I think that is suggests that the court was trying to impose a low-range sentence here, and yet on remand failed to reimpose a low or mid-range sentence, and instead sought to justify its original sentence. As to the cases relating to rehabilitation, the main thrust of those cases, while they have different facts, is that the court cannot maximize a single facet of sentencing, and in particular, the value of punishment. And in Edwards, it wasn't the comment alone that the court held to be problematic in terms of the court failing to consider rehabilitation. Instead, it held that there was a substantive problem with the sentence, and it remanded there were 2 of the drug offenses had been sentenced consecutively. It held that that was substantively improper, and that instead those sentences had to run concurrently. So here, I think the court is both maximizing the value of punishment, failing to sufficiently consider Mr. Fuerte Rios's youth and potential for rehabilitation, and justifying its original sentence rather than reconsidering that sentence in light of the lowered range. And for those reasons, I would ask this court to remand for resentencing. Thank you.
Thank you, Ms. Morris. Thank you again, Mr. Lofgren. We appreciate both of your arguments this morning. They've been very helpful. The case will stand submitted, and a written opinion will issue in due course. That concludes the oral arguments this morning for Division 1. The court will be in recess, and the bailiff may so announce.